jurisprudence on personality rights is all over the place right now.
Angle wherein creation of deepfakes affects people from marginalized backgrounds more negatively than those who are not.
Privacy and property are antithetical.
What implications does this have for free speech?
Our society, in fact, encourages a lot of free riding called fair riding. So is that per se a harm that is to be compensated monetarily?
There is no provision at the moment that targets the creation of content neutral and yet deceptive deepfakes.
A genuine privacy interest is not transactable.
And to do so with as much of academic engagement as is possible.
Whose harm really is at question here? Good evening, everyone. Welcome to the SpicyIP podcast. Today, we have Adyasha and Akshat with us to discuss the issue of personality rights. In India, where fame is currency and image is power, what happens when one's persona becomes someone else's business? And one of the ongoing issues that continues to garner the attention of many celebrities in India is the protection of various attributes of their personalities, such as their voice, image, signature, and likeness that are commercialized or unauthorizedly appropriated by others. In the past few weeks, months, and years, we have witnessed celebrities approaching different courts in India seeking protection of their personality rights. These include Chiranjeevi, Amitabh Bachchan, Karan Johar, Aishwarya Rai, Hrithik Roshan, and the list just goes on. So today we are here to have an interesting conversation on different facets of this entire issue. A brief introduction to our speakers. Adyasha is a researcher at the Institute for European Tort Law in Vienna, Austria. Previously, she worked at AZB and Partners in the areas of IP and data protection law. Adyasha has been associated with SpicyIP for several years now and was a student fellow in 2020-21. She holds a BA LLB honors from Hidayatullah National Law University, Raipur, and a B.C.L. from the University of Oxford. Akshat is the founder and counsel at AASA Law Chambers. He possesses comprehensive experience in IP laws, having worked as a senior associate at Sai Krishna and Associates, as a Wikimedia Race and Knowledge Equity Fellow, as a counsel at the Chambers of Senior Advocate Jayant Mehta, and as a judicial law clerk to Justice Pratibha Singh. He holds a BA LLB honors from Jindal Global Law School and an LLM in IP law from the University of California, Berkeley School of Law. We are very happy to have the both of you with us here today. Now, I'll start off with a basic question to you, Akshat. What exactly are personality rights? Are they only meant for celebrities? And if not, what relevance do they have for common citizens?
Hi, Tanishka. Thank you so much for hosting us. Hi, Adyasha. So just before jumping into what personality rights is, I think that's the basic question, right? Which, there are a few decisions of courts defining what personality rights is and what it is not. But one thing which is important for us to understand is that personality rights or right of publicity is a tort or a court-made doctrinal law as against a statutory provision or a parliament-made legislation, right? The doctrine of personality rights or the right of publicity comes purely from common law or court-made law. And the contours of that law are also doctrinally shaped. It's basically like a tort, the tort of publicity or the tort of commercial misappropriation. Now, initially when personality rights was conceptualized, it was conceptualized more onto sort of contours of passing off, which we often see in the context of brands, right? A unregistered brand being passed off by another unregistered brand in the sense of fulfilling the Trinity test of passing off, which we all know, right? Which is goodwill, misrepresentation, right? So over there, the establishment of goodwill is the prerequisite. Thereafter, deception and misrepresentation has to be shown for it to amount to a tort of passing off. Personality rights also started in this very way, where a celebrity, someone who had fame, which equal to certain amount of goodwill was the sort of monetizable asset that was deemed for them, which if someone else used in a commercial and a deceptive context was held to be violating their tort of publicity equivalent to the passing off right. But over time, you'll see that the concept of personality rights, the right of publicity, has been banked into the idea of privacy or the idea of a dignitary harm. So the ultimate harm that courts believe now that is being caused, which these rights sort of cater to resolving, is the harm to dignity or privacy interests. But paradoxically, these rights are again commercial rights. They are transactable rights. Right. So the case Puttaswamy judgment in a passing off orbital remark of Justice Sanjay Kishan Kaul recorded that personality or publicity rights are also covered within the realm of publicity. But what that remark does is make these rights inalienable, but or non-transactable, non-licensable, because one cannot transact in their privacy right. Right. That goes against the main John Stuart Mill or Bachittar Singh case claim that you cannot give up or waive away or alienate yourself from your core fundamental dignitary, privacy, or any other fundamental rights. But that's not what publicity or right of personality does. It's purely a commercial tort. So that's what is important to understand. This right is a purely commercial tort that initially started with the aim of or aligned with the concept of passing off, aiming to resolve deception and commercial misappropriation when together. Now it has evolved with the concepts of privacy being injected into it to become more of a free riding protection doctrine.
Right, Akshat, that's a very important intervention, and I'm glad you mentioned this aspect of privacy. That actually leads me to my next query. We also see courts invoking copyright protection in these matters. How does that become relevant? How are moral rights relevant to this entire debate? And how do you basically place IP law in this particular debate? If even in Orbiter, it has been held to be an inalienable right or a part of the right to privacy, then how does copyright law or generally how does property how is it founded in that?
Very, very interesting. So that's the core question, right? Because privacy and property are antithetical. So copyright or any kind of IP has in fact nothing to do with personality rights. And courts often confuse that, right? You'll see the IPD is hearing the personality right claims. Why? We don't know. Defamation is not heard by IPD. It's heard by the general bench. So commercial bench, right? The IPD rules, in fact, in the Delhi High Court, define intellectual property to include tortious actions related to privacy and publicity rights involving intellectual property issues. So this basically shows the conflation and the confusion which equates intellectual property to be something similar to personality rights or publicity rights, which are actually completely different. So it's important to distinguish. Copyright is a right that is given, a property exclusionary right that is given to a proprietor, a owner of a work product, an output of their labor or something which rewards them for them to be able to sustain themselves while doing that as their life's vocation. Personality rights, on the other hand, is not for a work product. It is for your own image, likeness, sound, which is not always developed by labor. It is often socially constructed merely because of your presence. It's fame, right, which is given to you because of your work, but not to your work, to you, by people around you. So it's culturally curated. Your image, your fame is an outcome of luck, cultural consciousness, what timing matters at that time, what is grabbing attention of people, as well as to some extent your labor over your over marketing your image and etc. Because now we have agencies doing that, right? So the point is that these privacy and property interests are very antithetical, and copyright has nothing to do with personality right claims. In fact, personality right claims are a different kind of property claim that is being injected through the tort mechanism, like how passing off is. But here the question is as to whether the claim seeks to the claim is grounded in deception or mere free riding of any sort. So the question which courts have not grappled with yet and need to grapple with in the coming future when the number of cases are increasing, of course, these are all ex parte. In case there's ever an opposition, or a claim, the main question which courts will have to throttle with is, are we saying that free riding per se is a harm that needs to be compensated economically, commercially? Or is some kind of free riding permissible, and is this that kind of free riding? Because this is non-deceptive. This is non-deceptive harm. So long as it's clearly labeled that it's not endorsed by the actor or the celebrity in question, this is non-deceptive harm. So whether mere per se commercial misappropriation is harmful is what courts have to figure out, and Indian courts have not figured out yet. Once you figure that out, you resolve the privacy property dilemma much better.
Right. We also see there being cases where deep fakes or in general artificial intelligence is being used to impersonate celebrities and influencers and create a sort of deception. So, Adyasha, I remember us discussing about the Ankur Warikoo judgment and how in that case, I think there was deep fake used to, sort of mislead the public into believing that it's a Warikoo who's endorsing certain kinds of investments. So how does deepfake, this technology, generally artificial intelligence, how does that play into the personality rights debate? All of these concerns also exist.
Yes, Tanishka, thank you. Firstly, thank you for having this podcast and hosting me on it. And secondly, thank you. That's a very pertinent question, especially in the times that we are currently living in. And as those of us following IP news headlines generally have noticed that a lot of personality rights orders that the Bombay High Court, Delhi High Court, and other courts have been delivering these days relate, in addition to merchandising related issues, to also to deepfake related problems and the creation of the creation of AI generated images or persona of these celebrities, which they then move against. To understand what a deepfake is, we need to know that these are highly realistic AI generated media. They could be voice clones, they could be images, animations, or the like, based on generative adversarial networks, which rely on deep learning algorithms that feed information and then come up with these results. Now, deepfake harms are being adjudicated under publicity rights existing laws, and publicity rights actions are what celebrities and their lawyers are resorting to handle such problems. But I don't think it is appropriate to say that it is the deepfakes in all circumstances are the same as other publicity rights problems, because they are rooted more in privacy and dignity related harms and also in autonomy concerns, and are distinct to a great extent from merchandising or basic use of name, image, and likeness of celebrities to sell products. And this has resulted in a lot of convoluted jurisprudence when it comes to regular publicity rights claims, which, as Akshat highlighted, are already interpreted in a very overbroad manner without doctrinal clarity, mixing the logic behind copyright theories with personality rights, which is an offshoot of the law of passing off. The problem with this is that, especially with cases like Ankur Warikoo and the like, when AI is being used to release information or advice, especially financial literacy, financial planning related advice, which is the basic, which is what Ankur Warikoo is extremely popular for. This risks misleading his viewers, his audience, and consumers in general about what kind of decisions they should make in related to their finances and planning. And they attribute this advice to Ankur Warikoo, creating, there is a deception harm, and B, this also raises real problems related to consumer protection, which is a matter of general public interest. And these are issues that need to be taken into consideration: the interests of the consumers, the interests of the public, and possible deception, and which may result in massive financial losses when you talk about things like mutual funds and investment in shares. That is something that really needs to be taken into consideration. But when a case like Ankur Warikoo is evaluated from a publicity rights framework, the focus then goes back to the basic two-step test, which already is, developed sort of erroneously from the passing of test, when all the court assesses is that whether there is a personality right, which in case of a celebrity, a YouTube celebrity will be there, and whether he is identifiable. The court does not delve into detailed issues of misleading and deception and confusion and harm caused to public by that. So we are using a private law framework to assess something that has significant public interest implications, and that is very much inappropriate. But this is with reference specifically to the Ankur Warikoo case. But in addition to that, deepfake also has many other problems when regulated or adjudicated from a publicity rights framework. One being that it is entirely an ex post facto remedy, wherein the deepfakes are first created and circulated, and then if it comes into, if it is noticed by the person who is featured in these deepfakes, then that person may go to court and seek remedies against it. The problem with this is that, firstly, the harm is done. The deepfakes are already circulated. What one needs instead of this is an approach that affects the upstream creation of deepfakes itself at the origin, because courts alone cannot bear the burden of, they can't discharge the duty, and they can't stop the problem of deepfakes by coming in after the problem has occurred. Secondly, this is something that celebrities are able to do because they have significant financial power, legal resources, and they have giant PR teams looking into whether any kind of negative publicity or such problems are taking place. Ordinary people like you and I, and most people watching this podcast and elsewhere, will probably not even find out if deepfakes, pornographic deepfakes, and any kind of deceptive deepfakes about them are circulated anywhere. And they'll also struggle, they might also lack the legal resources and the financial resources to approach courts and to derive and to be able to secure remedies from them. Deepfakes also have another massive angle, a very problematic angle, wherein creation of deepfakes affects people from marginalized backgrounds more negatively than those who are not. We can see this, if we simply pick up the issue of gender, we can see that among the many orders that relate to AI-related cloning, AI-generated deepfakes and cloning, the ones concerning male celebrities, regardless of what their profession, whether they're singers or actors, typically they relate to cloning or misattributed speech and the like. Whereas many of these which concern celebrities, regardless of what profession they belong to, they relate to pornographic material, obscene or sexual material. So this is a type of gender-based violence which targets women and targets other marginalized groups who are already at a position of disadvantage. So this is an issue that is completely obscure and not looked into by law when you rely entirely on a publicity rights based framework. And not to mention, publicity rights, as we have been discussing throughout this podcast, is already is already standing on extremely shaky legal ground with lack of judicial doctrinal clarity, and has no statutory basis. So therefore, transplanting the overbroad personality rights regime to the overall publicity rights regime to the case of deepfakes has been having really unclear and ineffective repercussions.
Yeah, and this also goes on to show what are the social implications also of the use of technology, the misuse rather. And do you then, Adyasha, think that the recently proposed amendments by MeitY, which require mandatory labeling, user declaration, and traceability of synthetic media, do you think that this would be a step in the right direction then, or would this be a piecemeal sort of a step that has no implications for in curbing the use of deepfakes? Or what do you think about this?
Thank you. Thank you for bringing that up. The new proposed amendments to the IT rules that just came out on October 22nd, they are certainly a promising step to the extent they show us that the legislature is looking into ways through which they can intervene with the problem. And some of the things that they propose include that platforms are now required to obtain from their users a declaration confirming that uploaded content is synthetically generated, which is basically the legal term for potential deepfakes. And intermediaries are also required to verify and embed indelible metadata identifiers marking their content as AI generated. The rules have happily given us a definition of synthetically generated information. But this is an intervention at the platform level, which helps platforms regulate and stop deepfakes from being proliferated. So the positives from this or from a framework like this is that this will probably reduce the load of litigation, deepfakes coming into courts, because a lot of potential deepfakes might be stopped at the stage of being uploaded to the platforms. So that is one positive. And the fact that deceptive deepfakes could be highlighted is something that needs to be looked into. However, there are some problems with as we are seeing, this is a proposed set of amendments, and it's not in place yet, and it's open for comments. And some issues that immediately pop up with regard to the proposed amendments is that the definition of synthetically generated information is extremely broad, and it basically says that information that is artificially or algorithmically created or generated or even modified or altered using a computer resource, which makes it appear authentic, is something that is synthetically generated information and needs to be flagged. Now, this definition has no exceptions and it has no reference to context, which means that it does not account for the regularly modified types of media that circulate on the internet all the time, which means that photographs, which when used with filters to upload online, can also come within the definition, and works which are in the nature of memes or alterations for humor and parody and satire. This kind of context is not taken into consideration in the definition, and therefore all of this is swept into it. So a clear change that is needed is the definition needs to be modified to account for context, to account for the kind of alterations that may be deceptive in nature. And there are also other issues that the kind of metadata that needs to be embedded requires the level of technical infrastructure that may not be within the capacity of smaller platforms or startups, so to say. So these are some of the problems that we can flag at the moment, and there are others that hopefully will come into the picture as the deliberation proceeds. But again, another thing that needs to be taken into consideration is that this covers the problem of deepfakes at the level of platforms. It does not tackle the creation of deepfakes itself. So at the moment, we don't have any law that specifically targets the creation of deepfakes. whether we need one or not specifically, or if it's covered by the IT Act related offense, is something that is a matter of debate. The offenses section of the IT Act only covers things like obscene and sexual material, or ones that violate privacy, or defamation, harassment, and the like. There is no provision at the moment that targets the creation of content neutral and yet deceptive deepfakes. And that is a gap that still remains, even if these rules are amended and eventually enacted.
Yeah. Thanks, Adyasha, for this answer and very interesting points highlighted by you on the proposed amendments. But this takes me to Akshat. Actually, I wanted to ask you, so if let's say there is label, and now even if the core issue of deepfakes being generated is not being addressed, but the intermediary is actually labeling the video and saying this is AI generated or whatever, so then there is no deception, right? So the consumer is being informed of the fact that this is a deep fake, or this voice that you're hearing, this is not Amitabh Bachchan's voice, this is an AI generated voice. So there is no deception. So then why does the celebrity then have the right to go to court and get an injunction against this, particular intermediary or whoever has created that audio? And what implications does this have for free speech? If you could shed some light on this, because if there is no deception, then how is this right arising?
Yeah, that's itself not clear, right? That's the core question, because ultimately, initially, these rights were rooted in deception. But now they have gone on to cover, without any statutory backing, cases which do not involve any kind of deception. Like you're right? If once labeling happens, however impracticable it may be, yet the point is that it's happened, right? Once labeling happens, there isn't any deception to bank on. So then the core harm which the doctrine or the common law doctrine seeks to sort of address essentially is of commercial appropriation, which brings us back to the initial question that we discussed as to whether commercial appropriation per se is a harm in law, in tort law. Right now, here in India, there's an old case called Ellora Industries of the Delhi High Court, where the court held that yes, commercial appropriation per se is a harm cognizable under tort law, relying on the INS case, the news case in the US. But the subsequent decision of the division bench of the Delhi High Court in Star versus Acquate, which was concerning the news, the rights of Crick Buzz to be able to showcase match scores, right? In that particular case, the court held that no, that right was not enforceable because firstly, it was preempted under the Copyright Act by the idea expression distinction, because you could not have claimed a property right over something which is prohibited to be propertized by the Copyright Act because of the idea expression distinction, and commercial appropriation per se was not recognized in India, right? So that's something which courts have to sort of grapple with yet. Like, for example, imagine there's the classic example which Wendy Gordon and others have given to say that all free riding is not harmful, is that imagine there's a game going on in a stadium, a very maybe a very popular cricket match is going on in a stadium, and you are a popcorn vendor outside the stadium. So you are attracting a huge amount of crowd to your shop because of the game in the stadium. That's free riding essentially. But are you supposed to pay any kind of licensing fee for that? No. We condone, our society, in fact, encourages a lot of free riding called fair riding. So is that per se a harm that is to be compensated monetarily? I don't think so. But of course, there are privacy claims. There are privacy concerns that are specifically visible to us. But that's the whole point of being a celebrity, right? You put yourself out there. You get the fame because of the people giving you that fame. It's not pure labor, right? It's not a purely individual consequence that fame is generated. It is built on a massive social infrastructure. A voice gains cultural power because millions of listeners make it significant, right? Make it viral. And that's what the point is, right? The fame is socially constructed as a matter of luck, as a matter of chance, as a matter of whims of the audience. And it's not something which you can claim yourself as an output of your labor. See, that's exactly, again, another reason for us to not be confused with IP. Because IP rights do two things in various theories, right? Number one, they reward compensate for labor. Number two, they realize that, okay, the resources these people are creating are non-rival resources. They are easy to be copied. And so we need to give them a way to sustain, because otherwise they won't be able to sustain themselves and pursue the creative field as a matter of their life's vocation. So then let's give them something that will enable them to sustain through an exclusionary right. That does not exist. That harm does not exist in the case of personality rights or publicity rights, right? Because these people are already successful and are celebrities, in fact. So they don't need an additional monetary stream for us to impose an exclusionary barrier from others or for others to use it as a matter of their commercial free speech, right? So me not being allowed to use a celebrity's image in merchandising a product, while clearly labeling that that person is actually not endorsing it, it's me who is using their image to further my brand value or to further my commercial speech, is not a harm, because it's clear that there's no deception because of the disclaimer. But that apart, there is no monetary stream deserved to the celebrity over here, right? As the case could have been in the copyright context, where because of a non-rival resource, there's need for enablement or sustenance fee. So that's an important thing to understand. There is no incentive argument here. There is no labor for reward argument here. So then what justifies the additional monetary stream? Some may say deception, but then again, you are countering deception through passing off principles. These are not passing off principles. These are commercial appropriation per se principles. So that's something which courts have not grappled with as of yet, assuming commercial free riding to be an actionable harm. But there will be a day where a defense will be put forth by someone in court, and courts will have to grapple with these questions.
So this basically tells us that the jurisprudence on personality rights is all over the place right now. And there is a lot of confusion on basic doctrinal aspects. What do you then think happens when there is, I mean, you spoke about this a little, but if there is no tarnishment of the actors or the celebrity's image, so then there is no harm, like you said. So this obviously means that there's a very strong public interest as also associated here. And there are free speech concerns also. This might lead to censorship or chilling effect. So what do you think is the implications of, what are the implications of how the courts have dealt with this matter on, parody, satire, and such forms of speech? And I think there was a Delhi High Court judgment in the Jackie Shroff case, I believe, wherein they touched upon this aspect in brief. If you could speak a little bit on it.
Sure. So you're right. There are social costs which are invisible often because these are all mostly ex parte proceedings, right? Competing interests are never heard. And what the consequence is that celebrities will control the circulation of their image, and then only approved meanings or meanings which are permitted to flow culturally will result in the ones dominating the meaning making, right? So that's what homogenization is, right? We're homogenizing meanings of people in our people who are cultural symbols in our cultural sort of realm. Courts need to ask harder questions. Is the use deceptive? Is the use defamatory? Will labeling eliminate the harm? Is there any other harm apart from lost earning potential? Does further income for the celebrity matter more than cultural speech? And the burden should not always fall upon restricting public engagement with culture, right? There should be proof of genuine socially recognized harm. And this is why we, I think, need some careful deliberation and a legislation that clears the contours of what kinds of harms are cognizable through this doctrine and what are not. Because otherwise, what personality rights or publicity rights do is concentrate control over public culture in the hands of the already famous and privileged, right? They are property rights camouflaged in dignitary claims, enforceable only by those who already have a market to make this restriction possible, exclusion possible, right? So there were a few sort of exceptions that were curated by courts. It was created by courts in one of the early cases where Justice Amit Bansal of the Delhi High Court was dealing with this issue of personality rights in the context of NFTs, right? So in that case as well, he had curated some kind of exceptions using the comic books case in the US and bringing out an exception that use for parodic representation or satirical representation of the faces of athletes on trading cards is not infringing personality rights because it's genuine parodic satirical use for the purposes of expression as against for the purposes of clout, right? So there, not being deceptive, being parodical, being funny, being satirical, the court upheld its usage. And so did the court in Jackie Shroff's case, where the use of Jackie Shroff's image on a t-shirt by a street vendor for funny purposes was held to be okay because it was comic and parodical. Now, all of these instances are very limited instances of market failure being addressed because assumably the licensor, potential licensor, celebrity would not license such images in the mind because they are comical, satirical. So you cannot curb that speech. And so you allow them to flourish. So basically responding to a market failure. But no one's questioning the formation of the market itself. The formation of the market itself is without any harm being there, right? So you are providing an exclusionary right without statute through a common law to the sort of commercial appropriation per se, as against any kind of misappropriation, and curbing cultural usage of cultural symbols in speech. So what's the basis of doing that? It's not really clear.
Yes, and these are some of the questions that courts have to ask when engaging with cases of personality rights. But even when they engage or don't engage with such arguments, Adyasha, what do you think can be a better way than overbroad reliefs that the courts are currently granting, injunctions that are being granted? What is a better way for courts to deal with such kinds of cases? And even let's say in cases where there is tarnishment of image or there is deception or some form of harm also being caused, what would be a better way for courts to deal with this? Should there be some change in law in your opinion?
Thank you for that question. I think that's the question that we all need to ask ourselves as far as publicity rights are concerned. As we have seen over the course of this podcast, there's a lot of confusion as far as judicial doctrine is concerned. At the moment, this personality rights jurisprudence as it exists is a mix-up of trademark related concerns, law of passing off from where the test has been adapted, and then it employs the kind of theories that are typical to copyright justification, as Akshat highlighted about incentive and reward and the like. And all of this has just resulted in a lot of inconsistency and lack of clarity. And some examples of that we can see in inconsistency within the decisions, between the decisions of courts themselves. Like, for example, the invocation of the right to livelihood, which has been done from different angles. For instance, in the case of Jackie Shroff, which Akshat explained very nicely, there the whole incident, the whole argument related to parody and satirical use by a YouTuber to create the Thug Life video of Jackie Shroff was something done as part of his offerings on his YouTube channel. And it was therefore seen to be a part of his right to livelihood and something that he was entitled to do. Whereas the courts have also interpreted it as from the opposite side, saying that the right to livelihood of the celebrity of Anil Kapoor himself is affected if unauthorized images or likenesses of his are circulated in the media. So this kind of inconsistency is something that tells us that it is probably not the best idea to leave it for courts to decide, at least as far as personality rights is concerned, because over the course of the past decade and a half, we have had a systematic expansion of the scope of personality rights, as well as a lot of doctrinal inconsistency. So I would say that a better approach is to codify it in statute, and to do so with as much of academic engagement as is possible, to take into consideration the views of stakeholders, academics particularly, because there is, at the moment, there is a lot of literature in India about the problems caused by this overbroad interpretation and shaky judicial foundation of personality rights, and yet somehow that does not factor into the court's decisions. Instead, if academics were academic opinion was sought by Parliament, and personality rights were sought to be properly distinguished from intellectual property related interests and codified, maybe that is again up for debate, as to, because a hasty codification could result in lack of clarity and potential harms to freedom of speech interests. But if done properly, that is something that would probably lead us into a clearer legal doctrinal foundation for these rights. And in doing so, there will also be clarity as to what extent deepfakes can be regulated by deepfake related harms can be regulated by publicity right regimes, and in what aspects of that are different, because there isn't only a small overlap as far as AI related circulation of images and harms is concerned. And so if we look at jurisdictions around us, some US jurisdictions, California comes to mind, have codified in their statute how privacy and personality rights are to operate. And the UK, on the other hand, solely uses the law of passing off. They do not have a freestanding personality right. They use the law of passing off, and when it comes to other kinds of harms, they sometimes resort to breach of confidence, tort of privacy, and the like. So there are different approaches that different jurisdictions have taken. But to summarize, I would say that judicial experience over the past decade and a half tells us that Indian courts are not proceeding in the correct direction as of now. And it's probably a better idea to leave it to the academics and to the legislature.
Yes, I absolutely agree with that. I think we would require a lot of deliberative, detailed processes going forward on this front. And the part on inconsistencies that you've highlighted, it just becomes clear when one looks at the different judgments that have come from courts over the years. And Akshat, do you have any points on what courts or the law in general can do better, to deal with these inconsistencies?
Sure. So, in my opinion, I think there's a need to firstly clarify the difference between privacy and personality rights. So, do not treat these as exclusionary property rights that are compensatable or transactable through monetary amounts, because a genuine privacy interest is not transactable, as was a primary principle of John Stuart Mill as well as of Bachiter Singh Supreme Court judgment, which basically says that fundamental rights are not alienable, are not waivable, and that's the core residing in them, right? Because you cannot alienate your dignity from yourself. So simple, right? So transacting it or commodifying that is something which is undesirable. Even if you do that, only do that to the extent of endorsement or merchandising. And when it's clear and it comes across clearly, and obviously use consumer protection strategies to make sure that the disclaimer is not a redundant one. So long as it's clear to an average consumer of content that this is not an endorsement, not a merchandising output, and does not deceive them from passing off perspective, maybe, then to that extent, I don't think there's any harm that needs to be curbed through the use of personality rights. Whereas, on the other hand, passing off principles would work well and much better to eradicate the consumer harm. So the harm is of the consumer over there. There is no harm to the personality of the celebrity as such. So touting this more as a protection from deception would help us limit the scope of the claim as well as help us justify the contour of the doctrine much, much better.
Thank you, both of you. These are very helpful suggestions. And as we conclude this podcast, we've seen how there is a great degree of doctrinal confusion, how privacy and personality rights, they are being conflated, and whose harm really is at question here. That is another important factor that we touched upon today. Apart from that, we discussed concerns surrounding the use of artificial intelligence and deepfakes, the recently proposed MeitY amendments to the IT rules, and we sort of navigated through these points to establish how this inconsistency, vagueness, and the overbroad judicial relief that is being granted is doing us no good, and why we require a greater engagement with academics and other stakeholders to sort of navigate our way through this mess. And I'm very grateful to the both of you for joining us today. And I hope that our viewers enjoyed this conversation. If you watched us, listen to us till the end, please do like, share, and subscribe to our channel. And do check out other posts on our SpicyIP blog. Thank you again.
Thank you. Thank you so much.
Thank you.
Adyasha.